But this question of environmental rule of law is a interesting evolution, because ever since, and I should go back to our heritage from Normandy, ever since William Marshall, who was a great knight, he came from Normandy to England. He was trained in Normandy, and William Marshall was the principal architect, along with the various barons in England, to extract from King John the Magna Carta. Magna Carta created the concept of the rule of law, and that the king is subject to law, and the law is somehow above the king. The same concept the Martian called upon us to recognize. And in the last 2 decades, as we've evolved environmental law, the enforcement and implementation of environmental law, the due process of law that came from Magna Carta, has come into the environmental rule of law as well. Antonio Benjamin is on his way down. But in the interest of time, let me shift the order a little bit. One of the individuals who had to put together for the UN Environment Program the first report on the environmental law was Scott Fulton, working with the Environmental Law Institute on behalf of UNEP. And so if I can invite Scott to begin this panel. We each have a short period of time. I'm sure if I say 7 minutes, it will end up being 10, but.
Okay, thank you. Thank you so much, Nick. Good to be with you all. And I'll vamp a bit just to let them find my slides, and so we get this in order. But many thanks to the organizers for the opportunity to participate in this important discussion. Like many of you, this is my first in-person speech in quite some time. I'm very pleased not to be doing it by Zoom for once, and feels very good to be rubbing elbows once again with friends and respected colleagues and thought leaders in this very important area. And it's welcome, particularly as we confront the precarious circumstances of our world. A special shout out to Nick, a leader among leaders and a dear colleague on these issues for a number of decades now, for his vision reflected in this program, and to Laura Duarte for the direction we all needed to hold such a program together and keep it together during these strange times. As you can see from, have we found the slides? We switched the order. Oh, okay, here we go. So if we can advance to the next slide, I thought it'd be useful just for a moment to describe the broader context of governance within which we have this conversation about environmental rule of law, because increasingly the environmental governance construct is multifaceted, not single-faceted. This diagram here is something we constructed at the Environmental Law Institute as a way of describing what is evolving. We're going to spend most of our time today talking about one of these 4 quadrants, which is law-based systems. But it is important that we recognize that there are some significant trends that are underway in some other areas that may ultimately offer some help in our quest for the right kinds of environmental behaviors and environmental performance. And just very briefly, working our way around this diagram, the second quadrant, which is styled as risk and brand management, is the province of private environmental governance. Systems that are at work and in the private sector that are driving environmental behavior in ways that are different than in years past, that are influenced by government expectations, but are ultimately driven more at this point by the demands of customers and investors. Because these systems are really about access to markets and access to capital, they're quite strong in terms of what they can produce and change. And government has an interest, I believe, in seeing this space optimized, because ultimately it can reduce the carrying load for government and trying to ensure compliance, among other things. The bottom two quadrants are basically technology oriented quadrants. Greener technologies here means both technologies that can reduce pollution pollution burden, but also systems that are emerging that allow for continuous loops of monitoring and correction. With artificial intelligence and machine learning entering that equation, it's reasonable to expect a dramatic expansion in automated systems of environmental protection. This will be of great help in our quest, I believe. The fourth quadrant is styled as environmental big data. Here, there's a particular kind of technology that's emerging that's quite important, and that is enhanced monitoring and sensing technology that is going to exponentially increase the amount of information we have about our environment and what's happening to it. Coupled with that is software technology that allows that information to be synthesized, analyzed, and in some circumstances by machines. So we're not limited in terms of capacity by the availability of human analytics, and then presented on communications platforms that expose that information in a way that can create a pressurized environment about the environmental behaviors that are producing the phenomenon that the information is showing. This all bears watching. It all bears our investment in some ways to try to make sure that these other quadrants are optimized. But if we could move to the next slide, we're talking here today about law-based systems, principally, which we think of as government-centric, at least in the first instance, and expressing various forms of command and control with some fairly set features: the establishment of normative baselines, environmental requirements and expectations that are expected to be picked up broadly, environmental impact assessments, so we understand the meaning of development and other activities for the environment surrounding those activities, surveillance and enforcement, and the tools that are available to ensure that those things occur. Ultimately, these law-based systems are rule of law dependent. Next slide, please. So let's talk a little bit about rule of law. Rule of law in the general sense, and this is a definition that tracks the UN General Assembly's articulation of rule of law, but it's consistent with what most of us think when we think of rule of law. And that is that for rule of law to form, for there to be rule of law formation, the law itself needs to be protective of fundamental rights. There needs to be access to justice to vindicate those rights. And the law must be observed and practiced by those who are covered by the law. These elements are interactive, of course. Access to justice is what ensures fundamental rights. Without access to justice, it's difficult to expect the law to be observed in practice. And in the absence of laws that at their root protect fundamental rights, it's unreasonable to expect that the respect that's needed to produce a general observance with the law is going to occur, because there's something not quite correct with the law itself at its core. Next slide, please. When we talk about environmental rule of law, the meaning at a very high level is rule of law in the environmental context. But it's importantly, in that context, rule of law has special gravity. And that's because of the long horizon, time horizons for environmental impact and attrition, which can mask the consequences of noncompliance. It's because of the natural resource connection to security and peace. There's ultimately even more at stake than just the environment, as important as that is. It's because of the connection to the level playing field needed for trade and economic activity. And the connection to fundamental rights, the right to life, the right to a clean, healthy environment, the rights to enjoyment and utilization of property. Next slide, please. In addition to having special gravity, next slide, please. There are also special attributes that have set up around rule of law in the environmental context. And we have this very helpful articulation from the UNEP Governing Council in 2013 in a Governing Council decision. This is actually a universal declaration in the sense that the Governing Council was moving in the direction of the the UN Environment Assembly, but this represents the views of all of the member states. This articulation offers a recipe for what has worked so far in building environmental rule of law, referring to these mutually supporting governance features, including information disclosure available to all stakeholders, public participation in the environmental decision-making process, laws that are written to be implementable and enforceable. Sounds easy, often not the case. And implementation and accountability mechanisms that are up to the task. Coordination of roles between government also seems self-evident, but a place where there's a tremendous amount of breakdown and duplication of effort and inefficiency. Environmental auditing, also known as environmental public integrity, to try to tamp down corruption and its role in the environmental space. And then criminal, civil, and administrative enforcement on the ground that is doing what it's supposed to do with timely, impartial, and independent dispute resolution as the guarantee mechanism, principally through the courts. Next slide, please. This slide just simply indicates the interrelatedness of these different elements and the fact that they all contribute to environmental rule of law formation. Next slide. These elements then also informed an undertaking by UNEP to begin looking at the state of environmental rule of law around the world. How are countries doing relative to this recipe, this cookbook for formation of environmental rule of law? This first report, Environmental Rule of Law, first global report, came out in 2019. My institute, the Environmental Law Institute, put this together for UNEP. We were pleased to have the opportunity to do that. Carl Brook, who's here with me, had the laboring oar for that. And it's an excellent report. I commend it to your reading. It's being updated now. There'll probably be a second global report in 2022. So be looking for that. I'm going to describe just briefly a few things that are in the report. Next slide. So some of the findings, and some of these things are self-evident, but we'll cover them quickly in any case. Just recognize that one of the good stories, the success stories in our realm, is a dramatic expansion in environmental law. There's no denying it. This is what the situation looked like in 1972. Next slide. Here it is in, next slide, please. 2017 looks like this. So basically, almost all countries have environmental framework laws in place and then some. This is a major accomplishment and a good thing. Next slide. Similarly, the environmental rights have taken a dramatic upward turn. Here's what the situation looked like in 1972. Next slide. Here's 2017. So you can see that in most of the world, there's a recognition of environmental rights, and these are usually codified in constitutions. Next slide. Also a dramatic expansion in environmental institutions. I think 164 countries now have an environment ministry or the functional equivalent of an environment ministry. That was not at all the case when we started this. Sorry, one minute. We've also seen an expansion in other important features of law like whistleblower protection and citizen participation rights, all good. Next slide. We'll probably breeze through the next. So lots of progress in these areas. Next slide. Next. The report also finds that there are important gaps that remain. These are some of the indicators of those gaps. Next slide. It also finds evidence of backtracking in many countries on environmental requirements or backsliding. Next slide. As has been mentioned already, it reflects the concern about environmental violence or violence against environmental defenders. Next slide. And it also reflects the concern about the continued presence of corruption as a mechanism that interferes with accomplishing our goals and objectives. Next slide. As well as continued failure to enforce or to properly enforce in a way that engenders rule of law formation. This is a huge concern. Next slide. Great concern, partly because the rule of law ultimately rolls up to every one of the Sustainable Development Goals. Next, I think we're almost done here. Next slide. So key takeaways, major growth in legal tools for environmental protection. It's very good. Major problems in actualizing those tools. That's very bad. Non-compliance remains a major factor. Failure to enforce and ineffective enforcement remains a major contributor to non-compliance. There's a tremendous amount of work to be done in the building of environmental rule of law. Look again for the UNEP update in 2022 and use these reports for advocacy for enforcement budgets and budgets for supporting capacity building work around the world, especially in the enforcement and compliance space. Thank you for your attention.
Well, thank you very much, Scott, for that wonderful introduction. It's now my privilege to introduce Mr. Justice Antonio Herman Benjamin. He is currently the chair of the IUCN World Commission on Environmental Law. I should say, in tribute to his accomplishments, one of his great achievements was the establishment of the Global Judicial Institute on the Environment. As was pointed out in many speakers, without strong judicial participation in the observance of environmental laws, the environmental laws often lack force. Antonio has been consistently over his career one of the great voices internationally to advance environmental law in all of its manifestations, and his leadership at the first Rio Congress on environmental law that WCEL sponsored with UNEP and others, which promulgated the first declaration on the environmental rule of law, was a major milestone in this effort. So, Antonio, over to you.
Thank you. Good morning. Bonjour. Well, first of all, many thanks to the organizers, especially my dear friend, Professor Nicholas Robinson, my other dear friend, Professor Emile Gaillard. I can't see her, but I know she's somewhere here in her team. Victor Tafour, who I'm sure is here as well, and the IUCN team. This topic, the environmental rule of law, has many components. And here in this panel, me, Scott, Gustavo, and Ayman will be just touching the surface of some of those dimensions. I'd like to invite you to a specific panel, a longer one, and not having Professor Nicholas Robinson as the enforcer of time, that is co-organized by the World Commission on Environmental Law, the Environmental Law Institute. Carl Brook is here somewhere, and UNEP, and perhaps Carl could later tell us exactly when this will happen, because there are so many events, but it's in the IUCN WCC program. I think I would begin with the beginning, because otherwise we cannot really grasp the power of the concept that we are dealing with here. The first aspect that we should address is why common law calls it the rule of law and civil law calls it, oh no, I have to keep my mask, I'm sorry. As a matter of protocol in Brazil, we have to do it. And I apologize. So, why is that? Are they different concepts? As you probably know, the concept of the rule of law is not a recent creation. It comes from the early 19th century, from England, Albert Dicey, meaning rule the government of laws or bylaws. That permeate common law. In civil law, the concept evolved from German law, Rechtsstaat, also from the 19th century, and then it became l'état de droit in French, Estado de Derecho en español, Estado de Direito in Portuguese. But they basically mean the same thing. And they mean, and I'll get later to this, not just that it's the government by laws, but it's the government by law. And this makes a huge difference. It's not just any law. And the huge difference is particularly important in environmental law. It's not just any regulation or set of rules that will qualify a country as being part of the environmental law community. The second aspect is, what's the relevance of this concept? We judges are pragmatic. Of course, we love legal theory, and most of the time we say that we are legal theorists, but at the end of the day, we want to see results. And the question is, does this matter? What are the consequences that we can extract from such a concept. First, the rule of law, and second, the environmental rule of law. There are consequences, and some of them are not just abstract, they are concrete. The first consequence, let's begin with the abstract ones. The first consequence is one that we have come to understand the rule of law as something that is essential, fundamental to the notion of a civilized people and a civilized nation. And no country nowadays wants to be seen as out of the group of the rule of law countries. So this is a political force of the concept. The next question is, in addition to the political repercussion, can we also see an ethical repercussion? Thus, the rule of law, in addition to being a normative concept, is also an ethical concept. And this brings us to an area that is not fully explored in environmental law, which is the characterization of environmental rights. We discussed earlier today rights of nature, but what are environmental rights? Do they fit in the classical categories of civil, political rights on one side and social and economic rights on the other side? Do they fit perfectly in the categories of positive and negative rights? And those are questions that we need to answer. Because one way of saying that the environmental rule of law is meaningless is to bring it together with a concept of the rule of law that's only procedural. And that is still pervasive. A notion that the rule of law has to do with laws, due process, but due process meaning under the present legislation, but no question about the quality of those laws. Do they protect human dignity? Do they protect fundamental human rights? And in the case of the environment, do they protect future generations? Do they take a holistic approach? Do they take into consideration the comprehensiveness of the responses or remedies that we need to put in place? So this has to do with the substance. And to me, and many of my colleagues, and I suppose my colleagues here in the panel, beginning with Professor Nicholas Robinson, we take the view that the environmental rule of law is one of procedural components and substantive components. And it's in the substantive components, and if you will, at the top of everything, that we put ethics, at the foundation and at the top, on the top of everything. Because we cannot imagine that a system that is completely sanitized from substance, from ethics, can be called a normative system. I'm talking about can be called an environmental rule of law. So it is substance and it is procedure. But it is also, as Scott Fulton pointed out, a concept that it's not vague. It's not in Mars, to use Ian Aguilar's metaphor in Mahise say. It's here. And if it's here, it needs to be implemented. So the environmental rule of law cannot be the rule of law in the books. It has to be law in action. It has to be implemented. And that's why the first report of ELI put such an emphasis on enforcement, on compliance, on implementation, because we want to see action. We want to see the results. We want to see those goals that are put in law achieved in different parts of the world. How much time do I have? Okay, 3 minutes. Good. The next dimension that I would like to discuss with you has to do with something different. And that is, who are the addressees of the environmental rule of law concept? Because we are not talking just for ourselves or to ourselves. We are the choir. And what's the next one? And I'll just stop there. What does it envision in terms of its subjective components? So let's begin with the first of those two questions. The rule of law is, and the environmental rule of law, is one that necessarily needs to take a holistic approach. Which means that because environmental law has to be at the same time comprehensive and specific, just look at the number of regulations we have on air pollution or water pollution, pesticides and so on. But at the same time, we need to have an umbrella, a coherent system. And the pieces communicate with the top, and the top communicates with the pieces. And the top, for us judges, and I suppose for the legal scholarship, is made up of environmental law principles. So the environmental rule of law is not just a systematic gathering of rules, but it's also a gathering of legal principles. And that's why it's so important to systematize those legal principles, including several of them that were mentioned today, and I'll mention perhaps in dubio pro natura and others that were not discussed. At least I was not here yesterday. Perhaps yesterday this was discussed. So I repeat, the environmental rule of law, l'état de droit de l'environnement, it's not just about a combination, a set of rules, but rules that have procedural aspects, substantive aspects, and a shell and a heart, a skin of ethical considerations. Second, it's not just made up of a potpourri of rules, but it includes legal principles. Some of them could be called general principles of law, adjust to the environmental context, like due process. Others are specific and were developed within the environmental law context. And finally, it is, from a systematic point of view, it is a combination of broad rules and at the same time very specific, often technical rules that we lawyers cannot understand because they are drafted by engineers and people from other areas or with other expertise. My very last point: who is the audience and who is part of it? Who are the addressees of what we are discussing here? Well, the first addressee is one that probably is not present in in the classroom. The addressee are the people. We want people to understand that protecting the environment is not just a tiny canton or a niche in the ocean of law, but it is central to the notion of law. Because we are not here protecting exotic species, we are protecting the community of life, the foundations of life, if you will. The second is civil society. And I mean the NGOs, those that fight, environmental defenders, that fight for the environment. Because we want to give them a single phrase that they can use in any circumstance when they see that the environment is being damaged, that laws are not being respected. They can say, we lack the environmental rule of law. There is no need to explain a lot when you say this. And thirdly, it's very important for judges, because judges are the final interpreters and implementers of the environmental rule of law. What judges don't understand is that they are also part of the concept, either as a force for good to help not just in implementing the environmental rule of law, but also through their decisions, their judgments, explaining what the environmental rule of law is. Every tiny deforestation, every attack on any element of the environment is an attack in the whole system of the environmental rule of law, and judges have a duty to explain this to the broader audience. But judges are also, or can be, a force that is not so good. A force, a negative force. One that blocks the advancement of the environmental rule of law because our eyes are in the past, in a jurisprudence that is not related anymore to the present laws and legal principles that we have. And my very last word, we judges also can play a negative role when we forget that to be a judge is not just to know the law or to exercise the power. And we have a lot of power. It is to exercise this power with integrity, doing what the law requires, but doing this in an ethical manner. Thank you.
Thank you very much, Minister Benjamin, for a most inspiring presentation.
Yeah, thanks, Carl. So the announcement. Sunday, September 5, from 11, 12:30, room H8B, and it will be, it's Mer de Corel, and it will be a fantastic panel.
So that's the next stage for the environmental rule of law at the forum itself. One of the great advocates who has also implemented the environmental rule of law, and by his many legal actions, I think, made the rule of law come alive, is Gustavo Alanis. He is the president of the Mexican Center for Environmental Law, and he has really for 30 years been one of the world's pioneers in not advocating, but implementing the rule of law. So Gustavo, over to you.
Thank you. Gracias. Gracias, Nick.
I'm going to speak in Spanish, if you don't mind. I know we have
Por favor.
translation, so I will take advantage of that. Quisiera ir a la parte práctica de empezar diciendo qué es a lo que nos hemos enfrentado en la práctica. Y seguramente voy a decir cosas que no son extrañas o distintas a las que pasan en otros países, pero es importante mencionarlas. Como ustedes saben, pues los problemas que tenemos en México y en otros países tienen mucho que ver con, por ejemplo, la contaminación de los cuerpos de agua, mares, ríos, lagos, lagunas, pérdida de áreas verdes, deforestación, que muchas veces ni sabemos los números, ¿no? En México, por ejemplo, uno googlea cuánto estamos perdiendo de bosques y hay cifras de 130,000 hectáreas, de 180,000, de 250,000, de 500,000. O sea, no sabemos con certeza, pero la estamos perdiendo. Obviamente la erosión del suelo, que es un tema galopante a nivel global. En México hemos perdido 75% de los manglares que originalmente teníamos. Pero además de eso, pues también existe problema de mal manejo de residuos peligrosos porque no hay la infraestructura suficiente. En un país como México, pues solo hay un par de confinamientos de residuos para el manejo de residuos peligrosos. Entonces, imagínense ustedes todo lo que se genera, ¿a dónde va a dar, ¿no? Algunos pueden salir por Basilea, otros pueden salir por un acuerdo con Estados Unidos, pero ¿dónde está el 30-40% restante, ¿no? Y es una pregunta que todos nos hacemos. Pero además de eso, pues tenemos sobrepesca, tenemos tráfico de especies, tenemos mal manejo de los residuos sólidos, un problema añejo que no se ha logrado resolver es la contaminación atmosférica en muchas de las ciudades del país, pero además perdemos áreas verdes y ahora enfrentamos el tema fuertemente del cambio climático, pero además enfrentamos violaciones a los derechos humanos ambientales y como ya se dijo aquí en el panel un par de ocasiones, también tenemos un problema serio con los asesinatos de defensores ambientales, 18 el año pasado. Entonces, esto es parte del reto al que nos enfrentamos. Ahora, no quiero decir con eso que todo sea malo, que todo sea negativo. En el caso particular de nuestro país, para poder avanzar en el Environmental Rule of Law, por ejemplo, tuvimos nuestra primera ley en 1971, ¿no? La primera ley ambiental federal en México. Tuvimos una segunda en el 82 y luego una tercera en el 88, que es la que está vigente. Tenemos el derecho constitucional a un medio ambiente sano, a la salud, al agua. Tenemos no solo la Ley General del Equilibrio Ecológico y Protección al Ambiente, sino también tenemos una ley de cambio climático, tenemos ley de aguas, tenemos ley forestal, ley de vida silvestre, tenemos ley de transición energética, en fin, una multiplicidad de disposiciones jurídico-ambientales. Hemos suscrito también una multiplicidad de acuerdos multilaterales y regionales. El más reciente que entró en vigor el 22 de abril es el acuerdo de Escazú, que retoma de alguna manera el principio 10 de la Declaración de Río, pero además habla de la necesidad de garantizarle a los defensores ambientales un espacio seguro para que puedan llevar a cabo su trabajo de manera adecuada. Pero además hemos evolucionado también en la parte institucional. Tenemos un Ministerio del Medio Ambiente, pero además tenemos órganos desconcentrados y descentralizados que se encargan de distintas temáticas, como es, por ejemplo, el Instituto Nacional de Ecología y Cambio Climático. Tenemos una Agencia de Seguridad de Energía y Ambiente. Tenemos a la Procuraduría Federal de Protección al Ambiente, Comisión Nacional Forestal, Instituto Mexicano de la Tecnología del Agua, Comisión de Áreas Naturales Protegidas, la Comisión Nacional Forestal, la Comisión del Agua, en fin, una multiplicidad de instituciones. Tenemos 180 declaratorias de áreas naturales protegidas a nivel federal, además de otras que hay a nivel de los estados. Tenemos un poder judicial cada vez más activo y que conoce cada vez más los temas ambientales, algo que no sucedía años atrás. Y también en la parte, digamos, académica, hemos logrado que el curso de Derecho Ambiental se vuelva una materia obligatoria en algunas universidades. Entonces, todos los alumnos que pasan por la carrera de Derecho en estas facultades tienen que tomar forzosamente el tema del derecho ambiental. Ahora, ¿cuáles son los obstáculos que hemos encontrado para la aplicación y el cumplimiento efectivo de la legislación ambiental? Uno muy importante es la corrupción, ¿no? Sigue prevaleciendo y en parte porque los sueldos y los incentivos que se le dan a los inspectores son muy bajos. Un inspector posiblemente gane 12,000 pesos. Eso equivale aproximadamente a unos $600, ¿no? ¿Qué puede hacer un inspector con $600 al mes? Y entonces, pues eso los obliga a caer en cuestiones de esta naturaleza. Pero además tenemos falta de recursos humanos, falta de recursos financieros, falta de recursos materiales para que la autoridad pueda hacer cumplir la ley, ¿no? En la actual administración, el recorte a la Procuraduría Federal de Protección al Ambiente ha sido del 40% de su presupuesto, ¿no? Y si hablamos del sector ambiental en su conjunto, en el 2014 destinábamos 0.38 del Producto Interno Bruto al sector medio ambiente y recursos naturales. En el año 2020 destinamos el 0.11 al sector. Entonces, si se dan cuenta, pues hay una disminución brutal en cuanto a los recursos y eso nos impide muchas veces poder llegar al Environmental Rule of Law. También creo que tenemos retos importantes en la parte de la capacitación y del entrenamiento. Hay que seguir trabajando con los distintos sectores de la sociedad para que estén capacitados en materia de derecho ambiental y en consecuencia pueda haber este ya multimensionado Rule of Law de manera implementado de manera efectiva. También enfrentamos un tema fundamental y creo que no es exclusivo de México y que tiene que ver con la voluntad política, ¿no? Si no tienes la voluntad política al más alto nivel, digamos el presidente de la República, podría haber programas, instituciones, presupuestos, intenciones, pero si en la práctica no hay realmente la intención de hacer cumplir la legislación ambiental, esta simplemente se va a quedar escrita en la ley, pero no va a pasar de ahí. También me parece que parte del problema que hay es que los espacios de participación social que existen hoy en día son poco utilizados o en ocasiones son mal utilizados. ¿Por qué? Porque la gente no conoce de las distintas oportunidades que tiene dentro de la ley ambiental para poder participar adecuadamente y en consecuencia, repito, o no los usan o los usan de una manera inadecuada. Pero tampoco podemos llegar muchas veces al Rule of Law porque hemos encontrado que las leyes muchas veces están mal redactadas. O no solo eso, sino que se contraponen algunas leyes entre sí. Por ejemplo, la ley ambiental puede decir una cosa en materia forestal y vas a la ley forestal y puede decir otra cosa distinta con respecto al mismo tema. O también encontramos que hay invasión de esferas, invasión en cuanto a las competencias que le toca a un municipio, a un estado, a la federación. También encontramos que las sanciones siguen siendo muy bajas en materia ambiental y entonces eso puede hacer que un agente económico que tenga una falta administrativa pues prefiera pagar una multa porque es baja y cometer la irregularidad. Pero también encontramos que algo que prevalece es que los intereses económicos se siguen sobreponiendo todavía a los intereses ambientales, ¿no? Y la pregunta que siempre nos hacemos es cómo y dónde encontrar el balance, ¿no?, entre ambos, que es el tema de la sustentabilidad que hemos venido platicando a nivel internacional desde que la Comisión Brundtland nos da a conocer el concepto de desarrollo sustentable, ¿no?, donde nos habla de este balance que tiene que haber entre crecimiento, desarrollo, inversión, creación de empleos y el capital natural, pero al día de hoy creo que nos ha costado todavía mucho trabajo poder llevarlo a la práctica. También parte de no poder llegar a ese Environmental Rule of Law tiene que ver con la institucionalidad. En Estados Unidos, y no quiero decir necesariamente que sea el mejor ejemplo, pero en Estados Unidos crearon a la Environmental Protection Agency en los 70s y hoy existe la Environmental Protection Agency. En México, desde los años 70, hemos tenido 6 secretarías de Estado diferentes, distintas, que se han encargado de los temas ambientales. Y finalmente diría que 2 cosas más en esta parte que tiene que ver con los obstáculos. Uno es que se sigue dando mucho la fragmentación de proyectos para la evaluación del impacto ambiental, cuando la ley dice que se tienen que presentar los proyectos en su conjunto. Y decir que pues también países como México firmamos muchos acuerdos, declaraciones en materia ambiental a nivel internacional, pero muchas veces pues no se cumplen o no se van a llegar a cumplir, como pudiera ser el caso del Acuerdo de París. México está yendo en contra de la transición energética y en lugar de apostarle a la energía limpia, a la energía renovable, estamos construyendo refinerías y estamos promoviendo el uso del carbón. Ahora, ante todos estos obstáculos, por supuesto que hay avenidas o hay acciones que se pueden ejercer desde el punto de vista legal para poder realmente llegar a un Estado de Derecho en materia ambiental. Puedes ir, por ejemplo, a la función pública y acusar a un funcionario de que no está haciendo su trabajo de manera adecuada, o puedes presentar una demanda civil, o puedes presentar una demanda penal por la comisión de un delito o un crimen ambiental. Puedes pedir información tipo en Estados Unidos que tienen el Freedom of Information Act. En México también ya existe algo como eso. Entonces es muy valioso hacerse de la información pública y después utilizarla. O puedes hacer consultas públicas, por ejemplo, en materia de impacto ambiental. O puedes ir a la Procuraduría Ambiental y denunciar 2 cosas. Que alguien está causando un daño, una afectación, un desequilibrio ecológico. O puedes denunciar que alguien está violando una ley, un reglamento o una norma en materia ambiental, y también puedes ir a la Comisión Nacional de Derechos Humanos para alegar que tu derecho constitucional a un medio ambiente sano está siendo violado. Concluyo esta presentación diciendo que por supuesto que hay muchos retos hacia adelante. Uno de ellos es la obligación, diría yo, que tenemos de mejorar y fortalecer siempre los marcos legales ambientales existentes, mejorar los espacios de participación pública que están en estos marcos jurídicos ambientales, y no solo eso, sino que se conozcan y que se utilicen adecuadamente. Por lo que ya dije anteriormente, hay que apostarle al Poder Judicial, ¿no? Yo creo que ahí es donde está la esperanza para el Environmental Rule of Law, ¿no? Los jueces cada vez están más versados, más entendidos sobre el tema de derecho ambiental. Los casos están llegando a los juzgados, a la Suprema Corte, y creo yo que hay un espacio de oportunidad ahí interesante. Me parece también que tenemos que fortalecer a las procuradurías ambientales, y por lo mismo hay que asignarles los recursos suficientes que se requieren. Y hay que aprovechar también las sinergias que hay entre el derecho ambiental nacional y el derecho ambiental internacional, porque hay una liga que no podemos negar. Y por supuesto, fortalecer o agregar nuevos tipos penales, como por ejemplo el ecocidio, que recientemente se dio a conocer por parte de un grupo de juristas a nivel internacional, ¿no? Y finalmente diría que posiblemente deberíamos de avanzar para efectos de que la evaluación del impacto ambiental no solo sea ambiental, sino que también sea social. Muchas gracias, Nick, gracias a los panelistas y gracias a los organizadores por la invitación. Muchas gracias.
Thank you very much, Gustavo, for that insightful review of the both the strengths and the limitations in attaining the environmental rule of law. Let me turn now to the presentation from Ayman CHERKAOUI. I'm very privileged that he is here from Morocco for this Congress. And I just advise you that he has been nominated, it's an honor to say, as the incoming deputy chair for the World Commission on Environmental Law. So it's a great privilege to have you on the panel, and over to you.
Thank you very much. The honor and the privilege are all mine. Good morning, good afternoon, good evening. First of all, I would like to acknowledge the leadership and important contributions, of course, of Minister Antonio, Professor Robinson, all the experts that are here in the room, and I'm particularly honored to be sitting next to you here. Thank you very much for that. On a different note, of course, thank the organizers for this most impressive event. And also on a less positive note, acknowledge that unfortunately, while so far the panels have been quite gender balanced, this current panel is not quite at the same level. But the next one, I believe, is also will be back at the norm for the next one. I'd like to start my very brief remarks not from where we stand, as there was this excellent presentation earlier by Professor FULTON that introduced us to the current state of environmental rule of law worldwide. While we were all impressed, and myself also, of course, in particular, if I may contribute one comment, and I don't quite know the methodology, of course, but I was a bit surprised by one of the maps when I didn't see Morocco as one of the countries indicated as one that has environmental rule of law enshrined. And that surprised me because as per Article 31 of the 2011 Constitutions of the Kingdom of Morocco, there is a right to healthy environment and the right to sustainable development. So maybe I looked at the map too quickly, or there are methodological elements I didn't quite capture. Excellent. Excellent. So I didn't want to start from where we stood, but I would like to start from where we quite literally are sitting, and that would be Marseille. And from a place of fiction, in a sense, I'm not referring to the legendary Sardine de Marseille that, according to this 18th century legend, blocked the port of Marseille for quite some time. I'm actually referring to a different work of fiction, although maybe the sardines was factual. That's why the local citizens of Marseille keep saying to this day. But I'm referring to Alexandre Dumas' Count of Monte Cristo. And one of the quotes that comes from this book quite often is, all human wisdom is contained in these two words, wait and hope. And I would like to follow that train of thought for the next few minutes. When it comes to weight and environmental rule of law, evidently what I'm referring to here is the dimension of time. And we saw that positively in the context of that maps, the comparison that you showed earlier. We saw that from a different angle when we were discussing with the Martian. And his or her or their frustration with the evolution or lack of evolution of concrete results. We also see it very much so in this inherent tension there is between the multidimensional urgency of action when it comes, of course, to the biodiversity collapse, when it comes to climate change and other areas. And on the other hand, the time it takes to be inclusive in consultations, in the drafting of laws, and taking into account the diversity of perspectives and also precautionary principles, and the time it takes to really measure the impacts and risk of the decisions that are taken. And there is this inherent tension that is quite an important component, I believe, of environmental rule of law. Also, still on environmental rule of law, there's the evolution of time per se. Now, I want to steer from polemic, but away from polemic, but evidently some of us are following what is taking place in the United States when it comes to Texas and United States Supreme Court and Roe versus Wade, and what it means for Roe versus Wade. And in a very different topic, but quite connected, in most introduction to environmental law courses in North America, one of the cases that we look at is Michigan versus the city of Chicago. And in there's that quite famous quotation from American Power, that public nuisance law, like common law generally, adapts to changing scientific and factual circumstances. But as was also indicated earlier, the politics play a role as well when it comes to that evolution, evidently. The role of environmental law and environmental rule of law plays an important role. Environmental rule of law also plays an important role in defining the balance of inceptions and sanctions when it comes to behavioral change. As we were discussing earlier, the Martian, we covered also the Red Queen race and the tragedy of the commons, and environmental rule of law has an important role to play there as well, of course. So when it comes to hope, and I think that would connect also quite well with the opening remarks from Minister about what he was referring about the role that environmental rule of law can play when it comes to fostering and not frustrating progress to the benefit of the communities of life in general. Evidently, yesterday and today, under the umbrella of peace with nature, we have seen both reasons to hope and reasons to have more cautious hope, as I would like to phrase it, when it comes to looking at the ethical underpinnings of that important concept. We looked at AI, future generations, rights and duties, evidently, government bylaws and government bylaw, as was also recalled by Minister Antonio earlier. In a nutshell, I think that the role of environmental law has an important role to play when it comes to both ambition and action, when it comes to setting ambition, but also following on this ambition by meaningful and concrete action. In that sense, I would like to also refer to that session we had yesterday about the legal indicators when it comes to the impact of environmental law. Education for sustainable development evidently plays an important role. But the role of environmental rule of law doesn't quite limit to what we have now. It is also important to look at what it can become in the future and how we move from here. And as such, I evidently don't want to preempt on important sessions that will take place, whether it is tomorrow, but also later today through, for example, the presentation about the future, towards our future by Professor Christina Voigt that will be chaired by Minister Antonio. And to conclude these very brief remarks, I would like to share a story with you that happened to me yesterday. So as I was on my way back here from having picked my badge at the Parc Chanot, I was in the metro station, and on the other side of the metro, there was this, I was waiting for the line to come here, and the metro had just arrived and left that was going the other way. And there was this gentleman that was on crutches, and he was carrying his groceries with him. So he was having quite a hard time. But he still took the time, I don't quite know what drove him to do that, to just turn around and look straight at me. And then he told me that in French, and I'll endeavor a translation right after, life is worthless, but nothing is worth living. So, la vie ne vaut rien, mais rien ne vaut la vie. And I think to a large extent, the environmental rule of law has such a tremendous potential and has already played to a certain extent an important role, particularly when it comes to the second part of that sentence, when it comes to nothing is worth living, and the importance of the environmental rule of law and environmental law in general, what we can do for all the communities of life, that in keeping in mind this axiom that nothing is worth living. Thank you very much.
Thank you, Ayman, for an inspirational conclusion to our panel. I understood that Nick BRYNER has, in fact, landed in Marseille. I don't know if he's in the room, but we can squeeze him in after the revised schedule. What I propose to do in order to get everyone out of here in time to go back to the World Conservation Congress opening is that we will accelerate the lunch, begin now, and be back here in time to hear from Tony Aposa. He could not attend. He's much saddened that he couldn't be here, but he recorded a very inspirational message, which we were going to play at 3:45. I think we can play that at 1:45. And the advantage of doing that is that at 2 o'clock, many people have to be here on Zoom. So we can't vary the presentation for the 2 o'clock panel because people have limited their times in different places around the world to be with us, as well as those who will be here in the room. So I think if we have a 1:45 opening. If you get back here about 1:40 from lunch, we can begin at 1:45. We can have the 2 o'clock panel. This will then allow us to also have the short memorial to those who have given their lives for the environmental rule of law, given their lives for peace with nature. We want to commemorate the defenders of nature with a short presentation. That is also going to be partially on Zoom at 2:45. And then we can have the closing ceremony with Christina Voigt, Professor Voigt from Norway, who will have arrived. So with your permission, I propose that as our way of going forward. I think over the lunch and coffee, you can seize all of the panelists and challenge them on the environmental rule one by one. But we will adjourn now for the lunch, which is outside in the hall. You can either have the lunch in the room outside, or as some of you did yesterday, take the elevator to the 5th floor, where there's a lovely view of the old port and the rest of this museum. So with that, I want to thank all of the panelists for this panel. It was an extraordinarily fine panel, as have all the panels been. And I would point out that the theme that we began with, that is the ethics that underpin environmental law, have played themselves through to the views of the Martians and also to the underpinnings of the environmental rule of law. So that theme has been a consistent one throughout our program. Thank you very much, and we'll see you at 1:45. Thank you.